Welcome to our video on the Mental Capacity Act. Throughout the course of this video, we will quickly explain to you what the Mental Capacity Act is and why it exists, so you are more informed when you make decisions around a person's mental capacity. The Mental Capacity Act of 2005 was implemented for the first time in October of 2007. The Act intends to give people 16 or more years of age the guidance and framework they need to make the decision on: is they are mentally capable of making important medical and financial decisions. The Act also intends to give carers the same guidance for them to be able to make that decision for their clients. If you clicked onto this video, your first question may have been, what is mental capacity? Mental capacity is the measurement of whether a person is capable of making decisions for themselves because of an impairment of the mind. According to the law, a person is defined as not being mentally capable if they are unable to do at least one of the following. 1. Understand information given to them. 2. Retain that information long enough to make a decision. 3. Weigh up information available to make a decision. 4. Communicate their decision by any possible means. There are 5 key principles of the Mental Capacity Act. In these next few minutes, we will talk you through each principle and what they mean. The first of the 5 principles states that we must begin by assuming that a person has capacity.
A person must be assumed to have capacity unless it is established that he or she lacks capacity.
The second principle states that a person must be helped to make decisions.
A person is not to be treated as unable to make a decision unless all practicable steps have been taken to help him or her do so have been taken without success.
The third part of the Act states that unwise decisions do not necessarily mean that a person lacks capacity.
A person is not to be treated as unable to make a decision just because he or she failed to make a wise decision.
The fourth part of the Act states that decisions must be made in a person's best interests.
An act done or decision made under this Act for or on behalf of a person who lacks mental capacity must be done in his or her best interest.
Principle 5 states,
someone making a decision or acting on behalf of a person who lacks capacity must consider whether it is possible to decide or act in a way that would interfere less with a person's rights and freedoms of action, or whether there is a need to decide or act at all. Any intervention should be weighed up in the particular circumstances of the case.
Now we will cover how we are to support someone to make a decision. It is important to remember that while a person may have the mental capacity to make one decision, they may not have the mental capacity to make a different one, or they may not have the capacity to make that decision at the moment, but may regain the capacity at a later point. This means that capacity decisions should be regularly reviewed to make sure they are still reflective of a person's capacity. 4 main points are included in the Mental Capacity Act Code of Practice to help someone make a decision. 1. Provide the person relevant information. 2. Communicate in an appropriate way that they are able to understand. 3. Make sure the person making the decision feels at ease. 4. Support the person making the decision. Next, we are going to cover enduring power of attorney and lasting powers of attorney. The Mental Capacity Act of 2005 created a new type of power of attorney known as a lasting powers attorney and LPA, which replaced enduring power of attorney and EPA. There are 2 types of LPA, a property and affairs LPA, which controls decisions made around finance and property, as well as a personal welfare LPA, which controls decisions made around a person's health and well-being. Now we are going to discuss advanced decisions. Advanced decisions are legally binding documents that a person signs while they are mentally capable, that decides what will happen to them financially and medically should they lose their mental capacity and be unable to make a decision in the future. For the advanced decision to be legally binding, it has to be made in writing and be signed by the person making it and witnessed. Furthermore, the person making the decision just be over the age of 18 years old. The next part we need to cover are deputies. If no arrangements have been made and a decision needs to be made regarding finance and property, such as selling a house or redeeming an insurance policy, someone can apply to the Court of Protection to deal with the situation in the best interests of the person lacking the mental capacity to make the decision themselves. The Act establishes some significant safety measures. 1. The Court of Protection, a court that can make declarations and decide whether a person lacks capacity to make orders or appoint deputies. 2. A public guardian, a public official who registers LPAs, deputies and supervising deputies appointed by the Court of Protection. 3. Independent mental capacity advocates, MCAs, people who provide support for those lacking capacity with serious decisions, such as life-sustaining medical treatment and the person's accommodation. 4. The criminal offence of ill treatment or willful neglect of a person who lacks capacity, a new criminal offence. A person found guilty, they be liable for up to 5 years of imprisonment. Deprivation of liberty is the final part of the Mental Capacity Act we will be covering in this video. Deprivation of liberty occurs when a person is under consistent support and supervision with an incapacity to leave. The person must also not have mental capacity to be able to consent to these arrangements for it to be classified as deprivation of liberty. The classification for when a person can be deprived of their liberty is not exactly clear, as it is dependent on the circumstances of the person who is being deprived. But deprivation of liberty should only occur if 1. It is in the best interest of the person to protect them from harm. 2. If it's a proportional response to the likelihood and seriousness of harm. 3. If there is no less restrictive alternative. We have now reached the end of the video. We hope this gave you a greater insight into the Mental Capacity Act and the inner workings that go into making sure we give adequate support to people to help them make informed decisions and get the assistance they need if they cannot make these decisions due to lacking mental capacity. If you still have questions about this video, make sure to look up more information so you can have an even greater understanding of the Mental Capacity Act. Thank you for watching.